Thank you, Mr. Chairman. My name is Wayne Steedman. I'm a special education attorney. I've been a special education attorney for 30 years. And I'm on the other side of the table from the Board of Education, so I applaud their support of this legislation. The IDEA, when it was passed with the idea that children with disabilities would receive a free, appropriate public education. And a duty was placed on school districts to ensure that children received that education. The way that education is delivered is through a child's IEP, or Individualized Education Program. And that IEP is developed in collaboration between the parents and the school. Usually that's a collaborative process, as Senator Hester pointed out. Typically there are no disagreements. But when there are, then right now, the way it's set up in Maryland is that parents must prove that the school system did not develop an IEP that meets their child's needs. The IEP that the law requires school system to be responsible for developing. At a hearing, the playing field is anything but level. School districts have control over the child's records, the educational records, and over 95% of the documents that are introduced into evidence in a due process hearing come from the school district. Those include the IEP, but progress reports, teacher anecdotal reports, evaluations, just about all the records, all of the documentary evidence. Witnesses, the school system has a plethora of witnesses, all of whom are then found to be experts in their respective field. Parents then must have their own experts testify, and their experts are often restricted in terms of how much contact or interaction they can even have with the child in the school. For example, if an expert wants to observe a child in school, they have to get permission from the school. They're limited as to how much time they can observe. They're limited as to what classes they can observe, and they're not allowed to even talk to the teachers. So it's not a level playing field. See, my time is up. Thank you.
A question, Mr. Steedman. You mentioned burden of proof on developing the IEP. Isn't it also an issue of non-public placement? In other words, doesn't this also cover a situation where the school system might believe they can provide adequate resources and supports for students with disabilities in a case where the parent might want a non-public placement, which might cost hundreds of thousands of dollars? Isn't that also covered by this?
Well, the unilateral placement, which I think you might be alluding to, is excluded from this portion of the bill. So the burden of proof, if
no,
parents...
I'm not talking about a unilateral where
Okay.
they just go ahead and put them in a non-public placement.
Right.
But if after some period of time, the parent believes that the child's needs can be better met or they aren't being fulfilled by the local school system and appeals the decision not to put them in a non-public placement, who's got the burden of proof?
Under that circumstance, the school system would have the burden of proof.
Okay.
Because they have to, if they have the burden of proof, according to this bill, they have to prove that the IEP is appropriate. And the IEP is what determines placement.
Right.